This is Paul Turner, the immigration barrister at Imperium Chambers. Yet again, Balajigari, probably tired of hearing about it or wondering what's going on and wondering if there will ever be a conclusion or any decisions or anything that will happen. Well, I've had a number of messages and people have contacted me and I've had various tweets as to what the position is. So I thought I'd post a short updated video really in discussion of two aspects. One, the right to work, and secondly, what is the upper tribunal and the Court of Appeal and how are they going to dispose of the matter and how is the Home Office going to deal with it? Well, firstly, in respect to the right to work, it seems that the Home Office they haven't published guidance, which they said they were going to do in respect of the cases. I've checked online, I've looked, maybe I've missed it, equally possible, highly fallible as an individual, but I haven't found anything published online. What I have noticed is that more and more of my clients and other people's clients are receiving letters from the Home Office which amount to a variation in their bowel conditions because they're still treated as people that have cheated, and the decisions that say that they are dishonest still stand until they're quashed and reconsidered, but they're receiving these letters that say that, which explain in the opening paragraph that they form part of the cohort of Balajigari cases and that the process of the consideration is going on, and then it gets to the crucial point, which is where they vary the bowel and they give them the right to work, and they also give them the right to study, and they also say that they're going to update, it said that ECS will be updated, that's the Employment Checking Service. In reality, the Employment Checking Service can often be a bit delayed. It can be a delay of in experience, a month or 2 months before the ECS actually reflects this. But the piece of paper that the individual is given, which says that they have the right to work, ought to be enough to secure employment. I say ought to be enough to secure employment because that depends on the individual employer. As I've discussed in previous videos and will discuss again, hopefully in conjunction with the Right to Work limited organisation, which you will find on my Twitter feed, that even having Section 3C leave, let alone a letter from the Home Office saying that you've got the right to work, might not persuade an unsympathetic employer that you can actually work in the United Kingdom, considering the huge fines that are meted out to those that employ people that are unlawful. But it's good news to the extent that the Home Office, albeit unpublished, albeit unannounced, are sending people that form part of the Balajigari cohort letters saying that they can have the right to work. There is an important update really for individuals and their representatives in respect of the right to work and the right to work issue. Previously, individuals were writing to the GLD. The GLD have informed me through Chambers that in future that they're not to write to the GLD. The GLD essentially washed their hands of the matter, probably got sick of receiving these innumerable letters from hundreds if not thousands of people asking for the right to work. What the Home Office are now saying is write directly to the Capitol building in Liverpool, in particular settlement or whatever, but Capitol building in Liverpool asking for the right to work. If you don't get a response within a reasonable time frame, then I consider perhaps a pre-action letter. Given the vast number of people that seem to be getting these letters, there shouldn't be any reason why you should be delayed, particularly if you've written. I mean, I have a number of clients who have outstanding requests for rights to work, and I'll be advising them accordingly if the Home Office don't liven up their act. Though whether the Home Office ever livens up its act is another matter. That deals with the right to work issue. It's not Section 3C leave, which is a pity, nor is it a BRP, which is an even greater pity, and the Home Office have yet to make a public announcement that they got it wrong, which is turning to the second issue, which is the disposal of the Balajigari cases. Now, as you'll recall from my previous videos, in Albert and Balajigari, the representatives didn't see fit to respond to the Home Office position statement. Now, as I've said, the Home Office position statement basically says, wait in turn, we'll reconsider your case, withdraw your JR, and there's a good boy. Now, if that happens, as I've said before, the effect of withdrawal is usually withdrawal without cost. There's no mention of acceptance of costs in the Home Office position statement, so I didn't expect there would be. And there's absolutely no indication as to what will happen to those that have left the United Kingdom. So the only responses that have been filed, as far as I'm aware, are those that have been filed by myself. As I say, they're done on a pro bono basis, as people have commented on lawyers and fat cat lawyers and in that respect. And in brief and recovering from the position of what I said before, potentially I've said that individuals should be put back into the position they were before the unlawful Balajigari refusals. They should be afforded all the rights and benefits that they were entitled to, and that should be done as soon as possible. As to whether the upper tribunal will accede to that request or whether there will be a further hearing if required, that's another matter. There's also the issue of what about those that have left the United Kingdom? Now, I've been thinking a little bit more about this. Now, Balajigari says essentially the Secretary of State didn't provide people with the opportunity of actually giving an explanation for the tax discrepancy or providing evidence such as from the accountant's fault or illness or what have you. Now, my position statement in respect of that, in respect of one of the clients, is that they should have their return facilitated, that the Home Office should bring them back to the United Kingdom or allow them to return so that they can put their case when the Home Office reconsiders, if they reconsider and if they decide to re-interview, so that the individuals can gather the evidence. Because quite frankly, in my view, for what it's worth, having someone leaving the United Kingdom and the Secretary of State saying, well, actually, we'll organise a telephonic conference with somebody in, say, for example, Bangladesh or Pakistan or India, and have a little chat over the telephone and ask them about the discrepancies and then refuse them, isn't really going to be as fair as an individual that's remained in the United Kingdom or been able to afford to remain in the United Kingdom and has the opportunity of approaching their previous accountant if it's the accountant's fault, or approaching the doctor if there's medical evidence or other extenuating circumstances. So it seems only just for me that the Secretary of State facilitates their return or allows them to come back into the United Kingdom so that they can participate fully in the reconsideration process, rather than having it done either by post or by some sort of telephonic conference. I can't forever, for the life of me, see the Secretary of State sending out letters and giving people extended periods of time or video conferencing. That's just simply, if that happens, then I'll probably eat my tie. I really don't foresee that happening. The last issue really is the time frame. Now, notwithstanding the fact that Balajigari came out in April and I'm speaking to you now at the end of August, and the Secretary of State hasn't implemented what the Court of Appeal clearly said, there was obviously the stay hearing where the Secretary of State would put forward their position statement by the 23rd. And then there'd be a response. Well, there wasn't from Albert and Balajigari, they seemed quite content. But as I say, in my position, I don't agree with the position statement. I don't think it goes far enough or recognises the unlawfulness and injustice that's been done to a vast number of people. However, an end might be in sight, and it might be in sight sooner than we think, because it's come to my attention that the Home Office have stated to the Upper Tribunal that they will be putting forward their position statement, or in effect a response to mine, in respect of how to deal with the cohort or all the JRs in the Upper Tribunal and Court of Appeal by the 28th of August, which No Great Genius will tell you is tomorrow. I hope to receive such a document, and as soon as I do, I will pass on what information it contains and my views as to whether in my view it's acceptable, and I'll take instructions from clients and see whether we agree or whether we wish to challenge it or take the matter further. But that remains to be seen. But at the moment, in short, right to work seems to be being issued to people, and the right to study seems to be issued to people. However, there is a delay with the ECS, though you should have a piece of paper that will confirm it. If you don't, get on to your lawyer. Make sure your lawyer writes the Capitol building at Liverpool. And as to the overall Secretary of State's position with regard to the disposal, we ought to know more tomorrow on the 28th of August. and then I will update you further. It's been a fairly short broadcast. Hopefully it's not been too boring. Please do not hesitate to contact me if you have an immigration problem, or a member of your family has an immigration problem, or you have any general questions. To get in touch with me, and I'll do my best to help or answer. You can contact me at Chambers on 0207 242 3488, or clarks@imperiumchambers.co.uk, or at my site, theimmigration.barrister.co.uk. Thank you very much for watching. Please subscribe or press the notification button. I believe it's on YouTube to the right of me. If you're watching this and you've got that this far, this has been Paul Turner, the Immigration Barrister at Imperium Chambers.